Welcome to Justice at Work, Employee Rights and Protections in the Workplace.
Welcome to Justice at Work, real talk from Filippatos PLLC, where fighting for fairness in the workplace is more than a profession, it's a mission. Each week, we break down the rights you didn't know you had, the systems stacked against you, and the legal paths that can set things right. Whether you're facing discrimination, harassment, retaliation, or injustice on the job, we're here to help you understand your power and how to use it. I'm Lisa Mosbey, the host, and today I'm joined with Parisis G. Filippatos, talking about constructive discharge and when someone is effectively forced to quit their job. Welcome, Jerry. Thank you so much for joining me again today.
Good afternoon, Lisa. Thanks for having me.
Jerry, what does constructive discharge mean in a legal sense?
Yeah, it's an odd term, right? It kind of sticks on the tongue sometimes. So what it means is that you've been forced to leave your job. You've resigned, but you didn't resign really voluntarily. You resigned because the conditions there were so impossible and so intolerable that you couldn't work there anymore. Now, why is that important? Most of the statutes that protect employees require that you not resign your position. If you're the victim of discrimination or retaliation or sexual harassment or any kind of hostile work environment, the law says that you can't just quit. You have to stay there in order to effectuate your claims. And the reason for that is one of the key components of damages in these claims is lost wages, right? What were you earning? And because of the unlawful conduct of the employer, what did you lose? Well, if you're terminated, it's easy because you had no choice. So obviously, if you were the victim of discrimination and then you were terminated, you're entitled to both back pay and front pay. Back pay being the amount of time you're out of work by the time the case is tried, and if you're still out of work, projecting forward how much longer you're likely to be out of work. But if you resign, you don't get any of those damages. So your claim is essentially gone. Each claim has two components, liability and damages. So if you resign, if you quit your job, you might be able to establish liability, but it's going to be very difficult to establish damages, economic damages. The one exception to that is if you resign because the conditions are so intolerable that no reasonable person could work there. This is typically found in harassment cases, whether race harassment or sexual harassment, and hostile work environment cases. But unfortunately, the standard is very high. You are adding an additional burden to yourself as an employee, as a claimant, the plaintiff, if you leave your job.
I want to clear this up a little bit. What kinds of workplace conditions, you mentioned a couple, tend to lead someone to feel that they have no real choice but to resign?
Well, unfortunately, because they don't know their rights, sometimes they think they can resign and they'll still have a claim. And if they knew that they would be losing their claim, they would be vitiating their damages by resigning, they wouldn't resign because any situation at work that leads one to want to leave is, somewhat intolerable, right? But if you know that you have to stay there, establish a record, speak truth to power, engage an attorney to help you do all that, and to bolster your claims, then you won't leave. So to refine your question a little bit, the kinds of scenarios that will allow for a constructive discharge claim, that will allow an employee to continue with their discrimination, retaliation, harassment claim, even though they resign, is typically having a situation, is typically a situation that involves some kind of overt, sustained harassment.
And then, Jerry, how does the law evaluate whether a resignation was truly voluntary?
Well, that's the voluntariness of it comes down to, were the conditions such that the law recognizes the exception to resignation equals no economic damages by allowing constructive discharge. So it's a very high standard. If we if so It's the reason it's very important, the minute that you start feeling that you're treated unfairly at work, to consult with an attorney, is that they'll tell you that right away. They'll tell you, I know you're in a rough spot. I know you hate it there, but you can't quit. If you want to pursue your claims, you have to stay there until we make a record, until you retain an attorney and they appear, and then try to negotiate some kind of severance for you, and separation, that has a substantial amount of money behind it.
Let's do a little comparison. What makes these cases more difficult to prove compared to a direct termination?
Well, direct termination has no issue to it, right? You're either terminated or you're not, right? You're terminated, and if you're terminated for an unlawful reason, you're entitled to damages. Period. Uh, if you resign, then you have to establish whether the resignation was voluntary, or rather, I should say, involuntary in the eyes of the law, i.e., were you constructively discharged? And that involves a whole bunch of subjective factors that it requires you to demonstrate, and you have the burden of proof as the plaintiff that the situation was so bad that no reasonable person would stay there.
I'm following you. That makes total sense. I want to go further on this evidence, though. What types of evidence tend to matter most when someone is trying to show that they were forced out?
Well, the best evidence is direct evidence. So, uh, if you consult an attorney, then you'll know what jurisdiction you're in and whether it's a jurisdiction that allows for one party consent to record conversations. If it is, and you record a conversation where your employer says to you, I've targeted, I hate you, and I'm going to force you to get out of here. I'm going to make your life so miserable so you leave. Then you have a pretty good case of constructive discharge. Another type of direct evidence, other than recording, is written evidence, right? If you have emails that demonstrate that your employer is really, really keen on you leaving and is pressuring you to leave, that's good evidence. Third type of evidence is essentially witness evidence, and that's the least solid, but still evidence. And that's where you have conversations with your employer where they make it apparent to you that you should leave.
How do employers typically respond when a constructive discharge claim is raised?
For it to be raised, you're putting it into legal context. So, talk about constructive discharge, you're putting it in the legal context. So, to refine your question a little bit, you are talking about, how do employer counsel respond to claims of constructive discharge? And for the most part, they are quite dismissive of those claims because, again, the standard is extremely high.
And Jerry, can you share an example of how a situation escalated to the point where resignation became the only realistic option?
I've had a number of cases where I represented an employee who was still on the job and suffering sexual harassment. In those cases, once the employee goes on record and establishes that they have been the victim of sexual harassment, um, you can negotiate a temporary leave, hopefully paid leave, with the employer while you try to negotiate an exit package for that employee. And the reason that you can get that paid leave is because you can say to the employer through their attorney, if you don't, allow for the paid leave, number one, there are going to be additional things that happen potentially that could make our client's claim stronger. And number two, our client could just resign because we think we have enough facts here and enough evidence here to establish constructive discharge.
I'm curious, Jerry, what options are available for someone trying to address these conditions before deciding to leave?
If they uh, feel that they've been wronged, and they call a competent employment attorney, that attorney will assess for them whether they have strong claims. And if they have strong claims, then that attorney will help them make a strong record and appear at the right time to negotiate a um, separation package for the employee. So that's really the option that you have. If you feel that the conditions at your work are becoming intolerable, you need to speak to an attorney, get on the record about what's happening to you, and then try to get an exit package, hopefully within a matter of weeks or months, not years.
And how does HR play into this? Should the employee go to HR before or after seeking information or help from an attorney?
Well, I always tell my clients that you should engage HR because they're likely to make mistakes and make your case stronger, because HR is really not there to help the employee. They are human resource professionals, but really what they're there to do is not um, augment the employee's conditions at work, but to protect the employer from potential claims. So you have to be wary of HR, but they're also the necessary conduit for complaints if you suffer something on the job that you think is unfair or unlawful. You have to go to HR and make a record, a written record.
And I'd love to get some input from you about how long these cases take. And I know each case is different, but can you speak to some of the experience that you've had working with folks who have had these cases?
I mean, each case is different. Each approach is different. At Filippatos PLLC, we pride ourselves on taking a deep dive into the case, and we try to use pressure to get the employee, our client, the best result as quickly as possible. We represent quite a few clients who are still working. That's atypical. Some firms shy away from those cases because they want the case to be neater when it comes to them. They want the employee to have been fired because, as we said before, that's a straightforward kind of situation. But we represent a lot of clients where we're essentially acting as executive coaches and crisis management. Do that again, as executive coaches and crisis management professionals, and we're helping them navigate whatever difficulty they're having at work while also making the record necessary for strong claims. If it's that type of case, at some point, push is going to come to shove, and the employer is either going to fire the employee, us having made a great record, or we'll say, hey, let's negotiate. In those types of cases, a majority of those cases for us, I would say over 60%, settle pre-suit. That means before any kind of official document is filed, and they settle within the 2 to 6 to 8 month time frame.
And I know when folks are working with your law firm, it's not just a lawyer that they're getting, it's also somebody who is a coach and who is going to be helping work through this case with them. For someone feeling that pressure, the angst that we have when we're in these situations, but they're unsure whether to resign or what to do, just feeling confusion, feeling lost. What advice would you give them today?
Do not resign until you speak to an attorney, and do not make any decision until you at least sound that decision with other friends, colleagues, family members, because you have to recognize that you're in crisis and you're not going to make the best decision by just reacting to the immediate problem that your employer is presenting to you. So be patient, be circumspect, get good advice, build a support system, and you'll get through it and you'll find your next opportunity.
Jerry, thank you so much for shining light on this today and opening up the doors to have this conversation and bring light to it.
Thanks, Lisa.
My pleasure. Folks, thank you for listening to Justice at Work, powered by Filippatos, PLLC. If you're dealing with workplace discrimination, harassment, or retaliation, or just want to understand your rights, visit philippatoslaw.com to schedule a consultation. And don't forget to like, leave a review, and subscribe to the show. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.